The Constitution of Zimbabwe provides that a person accused or suspect of a crime has the right to be presumed innocent until proven guilty. A warm welcome to #Know Your Constitution, hosted by Junior Court Counsel in partnership with Zim Daily. And today, to discuss more and about this section of the Constitution of Zimbabwe, I'm joined today by Mr. Msindo from UZ. So, Mr. Msindo, a warm welcome to the program.
It's a pleasure being here.
Thank you so much. So, Denzel, so today we'll be talking about Section 50 of the Constitution, subsection 1, sub D of the Constitution of Zimbabwe, which talks about the rights of the detained person. So before we quickly jump into that topic, maybe you can just give us a brief background about yourself.
So my name is Denzel Msindo, and I'm a Part 3 law student at the University of Zimbabwe. Yeah.
Thank you so much for that. So what do you understand by the Section 50?
So basically, Section 58 looks at the rights of accused and detained persons.
Mm-hmm.
So bail is provided for in terms of Section 50, subsection D, which says that any person who is arrested must be released unconditional or on reasonable conditions, pending a charge or a trial, unless there are compelling reasons justifying their continued detention. So this provision clearly enshrines the right to bail. That's where the right to bail is enacted in terms of the Constitution, and it's a constitutional right. And you can see it's within the Bill of Rights, so it's a constitutional right, so it has to be upheld. And Zimbabwe is a constitutional abiding country, and that right is upheld by the Constitution. So bail normally is hinged on two principles. It might be two or more, but mainly two principles. An accused is presumed innocent until proven guilty. So that's one of the grounds which warrant the release of a person on bail. Because when a person is arrested, that presumption of innocence, it still waves within the right of that person. So a person is presumed innocent. Hence, bail should be accorded, unless there are compelling reasons justifying their continued detention. So that's one of the prime grounds that a person is presumed innocent. And the presumption of innocence pending trial, it leans on the accused person. Hence, an accused person should be released on bail. Another principle which supports bail is that the issue of whether or not an accused person should be released on bail turns on what is in the interest of justice.
Okay.
What is in the interest of justice is paramount when hearing bail issues. A person is admitted on bail when it is in the best interest of justice to be admitted on bail.
Okay, so on that regard, you mentioned something that a person is not guilty until proven guilty. But then we have seen a number of times where a person is denied bail. And under what circumstances can a person then be denied?
As I have said before, a person can be denied bail on a ground that it is not in the interest of justice. Let's define what is in the interest of justice. If, let's say, you have committed a third stage offense in terms of the Criminal Procedure and Evidence Act, it might be difficult for you to be admitted on bail because it's not in the interest of justice for you to be admitted on bail. You have raped a minor. You have raped a minor who is related to you. So you cannot, normally the presumption is you might not be admitted on bail on that ground because there are still witnesses who are still yet to come to court. So if you are released on bail, you are likely to compromise the proceedings before the court. Hence, you might be detained on that ground. It might not be possible for you to be admitted on bail. We can also look at the nature of the offense in question. Let's say you are being accused of committing treason. It's a highly political offense. So you might not be admitted on bail pending those circumstances, but circumstances differ each and every case. So a case of bail is decided by the court on a case-to-case basis. Circumstances differ. But normally bail is a constitutional right. A person should be admitted on bail unless the contrary is shown, unless it is not in the interest of justice.
Okay. Well, you heard it. But maybe some of the questions that we can, that people out there would want to ask is, well, if I'm said to be a detained person or when someone is arrested, what kind of rights do they have?
Yeah, when you are detained, remember, accused person, as I have said before, you are still presumed innocent until proven guilty. So you have got a right. Normally, when you are presumed innocent until proven guilty, your right to liberty you have got your right to liberty, but this right is limited. The right to liberty is limited in terms of Section 89 of the Constitution, which is the limitation of rights. But you have got your rights. An accused person has got a right. You have got rights to access to your lawyer, right to a free and fair trial. So regardless of you being leveled some charges against you, you still have those rights in favor of you. So bail, normally it depends with this stage of proceedings. Before trial, pending trial, the presumption of innocence is in your favor. But pending appeal, it's now a different case altogether. So basically, accused person have got rights. They have got rights to a free and speedy trial.
Okay.
Free, fair, and speedy trial. You have got rights.
And on that, Denzel, you mentioned something about speed trial. But a couple of times we've witnessed whereby a case can be prolonged up to 2 years. If we look at the case of Job Scala, where it took, I think, more than a year for it to be, to be dealt with. What actually happens for a case to be said, to be prolonged for that long time without a person being given bail as well under those conditions?
Yeah, I would want to comment on the Job Scala issue because I am not quite aware of the circumstances around it. But what I know is cases differ. Cases might take 2 to 3 years depending on the complexity of the issues which are within that particular case. So cases differ. But generally, a person is accorded a speedy trial. There are remedies to that. If you feel like you have not been accorded a speedy trial, there are legal remedies. You can apply for permanent stay of proceedings. There are legal remedies within the Constitution which allows for that, but generally a person is entitled to a speedy trial. You can see cases stretching as far as 2 years. It depends on the complexities of the issue. Let's say there's still evidence to come, we are still to subpoena some witnesses, so it depends. But generally, it is a constitutional right that you be accorded a speedy trial. Failure to do that, there are legal remedies. You can pursue those.
But is that a right for, when we talk about speed trial, is that accorded to everyone?
Yeah,
because it seems like some people, they can even ask you for speed trial and their case, just they commit a crime today and tomorrow they are in the court and the case is dealt with. But then there are certain circumstances where we witness a number of people, they commit a crime, they continuously put on remand, or further.
Yeah, basically, if the law says a person should not be placed on remand more than 2 times without a reasonable cause. If you found yourself being placed on remand without a reasonable cause, you can still apply for something called the refusal of a further remand. There's a legal remedy to that, but generally, I have seen cases being expedited within the magistrate court. Plus, it also depends on the workload at the magistrate or at any other court. Those courts, they have got different workloads, but they try to speed those trials. They try to expedite cases so that they don't keep on infringing the right to a free and fair trial. But I'm not saying there are no cases which have been prolonged. They are, but generally the presumption is each and every court, whether the magistrate court or the high court, they should try and expedite cases.
All right, thank you so much for that. Well, you heard it, viewers. And then on the issue of remand,
yes.
Like what grounds is a person put on remand instead of just being given maybe a way of just going to the prison? Why are some people are placed on remand?
Initially, when we are arrested, the first thing when we are arrested, we are placed within remand within 48 hours.
Okay.
It cannot spill over beyond 48 hours unless there are certain circumstances which are at the remit of the law. But normally a person is placed on remand, and if you are placed on remand and you feel like there are no reasonable grounds for you to be placed on remand, you challenge the remand. There is a legal remand. You challenge the placing of the remand. So that's where now bail comes from. If you are placed on remand and you agree that there are reasonable grounds for you to be placed on remand, you can then now apply for bail. Bail is that constitutional right which allows you to be tried whilst coming from the comfort of your home rather than for you to be within remand. So that's where bail comes in. And bail it can be either oral or written. Normally, it's oral application for bail. And the applications for bail are yet timelessly. They are yet as a matter of agency. If you apply for bail, whether oral or in written, the magistrate or the presiding officer within that court should hear your case on an urgent basis.
Okay.
And when you are making an application for bail, you are free to you state your own grounds on which you pray to be admitted on bail. But take note, those grounds are at the discretion of the court. The court might accept your grounds which you have stipulated in your bail statement or not. So it's still at the interest of the court to see whether those grounds are in the interest of justice. So when you make your bail application, you state your ground. I shall report to a certain police station from such and such a date.
But Mr. Msindo, under normal circumstances, what then? What kind of facts that guides the presiding officer to then say this one is their plea for bail is acceptable or not?
Normally, it depends with the nature of offence, as I have said. Normally, when you are dealing with any other offence besides those listed in the third stage of the Criminal Procedure and Evidence Act, the onus is on the state, which is the dominant litis, to say why should you not be admitted on bail. So the prosecution has got the onus to place reasons why this person should not be admitted on bail. But when you are accused of those third stage offences, your rape, your murder, the onus is on you on why you should be admitted on bail. But after everything is said and done, the presiding officer, the magistrate, and the state should take note that bail is a constitutional right. And the tenets of the Constitution with regards to the presumption of innocence also states that pre-trial detention should not constitute natural punishment. A person we should avoid, at most instances, we should avoid pre-trial detention because that presumption of innocence, the person is just presumed innocent. He has been accused of theft, yes, but we don't know whether he is going to be acquitted or not. So he is still presumed innocent. So after everything is said and done, when the prosecution and the presiding, whether the judge or the magistrate is deciding cases of bail, they take cognizance of the issue of presumption of innocence. But there are some certain circumstances which, as I've said before, it won't be in the interest of justice to admit that person on bail.
Okay, but maybe just a quick question. Is it possible for an accused person to get a free lawyer in Zimbabwe?
Yeah, normally I wouldn't want to say it's. I know of Zimbabwe lawyers for human rights, they help. I don't know what's the rationale for them, what's the standard for them, what are the conditions, but they help. If you feel like you need a lawyer, yeah, there are some lawyers which are appointed by the court, those pro-duo cases, but they are only appointed on cases of high-profile cases like which constitutes capital punishment, like your murder. Especially if you are at the court, if you are accused of murder, you are appointed a free lawyer by the state by virtue of pro-duo cases. So the state appoints a lawyer on behalf of. But there are some organizations, I don't know a lot, but there are some organizations which have people. I know of Zimbabwe Lawyers for Human Rights. They've helped quite a lot of people. So you can always approach those lawyers, those organizations if you like. You need a lawyer. Really.
Okay, thank you so much. So, what advice can you give to our viewers in regards to bail application?
Yeah, people should not be afraid of the courts. People should exercise their right because bail is a constitutional right. So people should explore their right. It is a constitutional right. Don't be lied to or what. You can apply for bail, but as I have said before, it is at the discretion of the court to give you bail or not, taking into consideration if it is in the interest of justice. So you might want to say the court has got an interpretation of what is in the interest of justice. So they use that interpretation for you to be admitted on bail. So basically that's bail. Plus there's also bail pending appeal. Yes, you have been convicted of an offense. You can still apply for bail pending your appeal to any superior court also.
Well, thank you, our viewers. Well, thank you so much, Mr. Msindo. You have heard it from Mr. Denzel. Bail can only be given when actually the court has decided upon given an evidence and also some facts whether you deserve bail or not, as long as it is within the interest of the justice. Otherwise, thank you so much and have a good day.